Hello and welcome to the FY2023 FDOT Highway Safety Subgrant Overview. My name is Danielle King. I'm the Operations Coordinator for the FDOT State Safety Office. Today I'd like to go over with you the FDOT State Safety Office Subgrant process and how it affects you this year if you've received a 2023 subgrant. As you can see here in this visualization, the process and timeline from submitting a concept paper to actually receiving a subgrant agreement is pretty lengthy. You'll see that your agency submits those concept papers in early January, February. There's a lengthy review and development process for the actual application that goes to the federal agency that funds us, the National Highway Traffic Safety Administration, or NHTSA. NHTSA also has a 60-day review period from their July 1st deadline that we have to submit it to them. And so by late August, early September, they let us know which of our projects that we submitted in our highway safety plan were actually approved for funding. And then we coordinate with those agencies that were selected to actually compose a subgrant agreement based on what was actually approved. This year and for the past 3 years, all concept papers and subgrant agreements are executed via our system IntelliGrants. For those of you who may not have been involved in the initial stages of this process, your agency submitted a concept paper back in January, February, and identified a traffic safety problem that you would like to receive subgrant funding to resolve. Based on the program area that was selected for that concept paper, it was assigned to an FDOT program manager for evaluation. During that evaluation, the program manager reviews your concept paper elements to make sure that it makes sense, to make sure that what you're asking for is actually eligible for NHTSA funding, and also to make sure that whatever countermeasures or proposals that are being offered actually are in alignment with the Strategic Highway Safety Plan. In addition to just the concept paper elements, the agency itself is reviewed for past performance with grants, past performance with any equipment use that was purchased with grant funding, and compliance with the single audit requirements to give audits if you receive a certain amount of federal funding each year. All of these elements determine whether or not your agency's concept paper is recommended for funding. If the FDOT program manager recommends your concept paper for funding, it goes to the FDOT administrator and chief safety officer for review and approval for inclusion in our highway safety plan application that actually gets submitted to the governor's highway safety representative for approval to submit to NHTSA for funding, and then actually to the National Highway Traffic Safety Administration, NHTSA, for official approval to allow us to actually execute subgrants for the FY2023 year. Once that approval is received from NHTSA, we then begin what we call the subgrant development process with the agencies that were actually selected for funding. Because in order to get from a concept paper to an actual subgrant agreement, we actually have to develop that agreement. All concept papers that were submitted will either receive a letter of selection or a letter of non-selection. These letters were mailed physically to your agency head. If for some reason your agency did not receive your letter of selection or letter of non-selection for a concept paper that was received, these letters actually exist within the system. So anyone who has access to the IntelliGrant system can log in and actually see an electronic version of that letter. So it's always there. So if for some reason nobody received the letter, it does exist within the system, so anyone with access can retrieve it. The screenshots show where on the forms menu you'll see at the very top, the first form that's available is your letter of selection or non-selection. In the letter of selection, it does indicate the total amount that was funded for the fiscal year compared to what was asked for. In the letters of non-selection, it indicates the reasons why the letter was not selected to give you some feedback for applying in the future. So as we mentioned, concept papers don't automatically become subgrant agreements. because what was requested in a concept paper may not have been approved in full. So in the system, we have a status called subgrant development. This is the stage where the subrecipient, you, have the opportunity to see, okay, what was actually approved based on what I asked for. You'll also see where FDOT has added standard objectives and evaluations that they expect to be conducted throughout the year. You also see the terms and conditions of receiving a subgrant, and you have the opportunity to review these things, make sure that your agency is willing to comply with them, and that everyone is on the same page before we actually execute a contractual agreement between our agencies for you to do good things and for us to reimburse you. One thing I'd like to emphasize regarding FDOT State Safety Office subgrant funding is it's unlike any other federal funding that you've received. There is no 10% transfer. There is no asking for forgiveness rather than permission. Your subgrant agreement says what it means, and it means what it says. If it doesn't say it, it doesn't mean it, and it will be evaluated based on what it says. So the very first page of your subgrant agreement is the Part 1 General Administrative Information. And as simple as the title says, that's exactly what it is. It's general administrative information for the grant. The first being the project number, the second is the FDOT contract number. These are how your subgrant is identified on the Federal Highway Safety Plan that was approved and how the contract is tracked within the FDOT financial system. It's imperative that both of these numbers be included on any and all correspondence you send to our office. If you're sending an email, if you're requesting a required approval, make sure that the project number and contract number for this particular subgrant are included on that correspondence. This is imperative if your agency receives more than one subgrant. The second most important thing about this very top is that subgrant award date. We do our very best to try to get these things awarded as soon as possible. However, they are not eligible for reimbursement or activity until that award date. Just because the federal fiscal year begins October 1st does not mean that all subgrants are awarded on October 1st. Many of you may have subgrants that are still in development process. So that award date is the first date that costs are eligible to be incurred and reimbursed. And just a little system hack, because our subgrants are executed via an electronic system, the last 4 digits of your project number are another way that you can quickly search your subgrant. So if you have 4 different subgrants, but you want to talk to me about one specific one, so say in this case, MC 2021 000117, you don't have to give me that long sequence when you're calling to ask me a status or a question about your subgrant. It's like, hey, Danielle, project number 117, can I do this, that, or the other? So this is a way that you can communicate efficiently with your project director just by providing that last 4-digit number, and or if you're trying to search within your own system to review which document, you can do a search by the last 4 digits. So in addition to the actually FDOT provided information like the project number, contract number, start and ending date, you have identified your subrecipient agency and implementing agency, so who's fronting the cost for this and who's doing the work, and the chief financial officer who will be responsible for the single audit compliance information, the project director who will be responsible for oversight and execution of the terms of the subgrant agreement, the financial reimbursement contact who will contact when we have questions about what was submitted for reimbursement, and the project activity contact, which would be the second line of information regarding the status of the subgrant execution. One thing I want to highlight here is whomever is identified in the section for project director. This role is for oversight and is not eligible for any benefit under the subgrant agreement. So if you are listed as the project director and you intend to work the grant, receive overtime reimbursement for the grant, travel under the grant, you cannot be the role of project director, because the project director is an oversight role and cannot have that ethical conflict of oversight versus being able to influence benefit for themselves. So your grant says what it means and it means what it says. So if it says you're the project director, you cannot receive benefit. If you need that to change, we need to amend your grant to identify someone above you that could be oversight for the agreement that does not intend to work the grant. So the second part is your project plan. So in this plan, you identify what the traffic safety problem is in your area and how you intend to use subgrant funding to solve that problem. It also identifies the objectives that you intend to accomplish throughout the year and how you're going to evaluate whether you do or do not meet that. I understand that a lot of agencies have grant writers that do this for you and have absolutely no involvement in the actual execution of the grant. If you are involved in the execution of this grant, it behooves you to take a look at what the project plan says that your agency is going to do, because your subgrant agreement says what it means, and it means what it says, and you'll be evaluated on what it does say. So if it says that you're going to accomplish 4 HVE details within a month, and there's no way in heck that that's possible based on your manpower, we need to get the terms of this contract amended so that you can actually be compliant when you're evaluated on whether you did or did not meet what your objectives were for the subgrant. So again, it says what it means what it says. If it doesn't say it, it doesn't mean it, and it will be evaluated based on what it says. So again, if you're involved in this process, please make sure you understand what your agency has contractually committed to. And if it's not reasonable, you need to work with your program manager to get those terms amended immediately. So part 3 is actually the budget detail. This indicates the maximum amount of federal funding that can be reimbursed for a line item specific. There is no combining of line items or switching of categories. The amount of funding that is approved is for the maximum amount listed in that line item for that specific category unless amended. So grant says what it means what it says. If it doesn't say it, it doesn't mean it. If you need it to say something else, you need to change it before you go and spend money that exceeds that area. Because as nice as we are, we will absolutely forgive you all day long. We will just not pay you. So definitely not a forgiveness over permission situation. Make sure you get your contract amended before you start spending above what is approved. So let's talk about the different categories within the budget detail. First being personnel services. So line items listed in this category identify positions that are eligible for reimbursement for hours worked towards the subgrant. It also identifies specific benefits that are eligible for reimbursement for those hours. Number 1, only those costs that are worked on the grant are eligible for reimbursement. Number 2, only the benefits that are identified on the subgrant are eligible for reimbursement. DOT cannot contractually reimburse costs that are not specifically identified. So in our example, we have a project lead, which has FICA, retirement, and workers' comp. And then we have an OPS position, which says FICA and workers' comp only. If the agency intended to receive retirement for OPS, we would not be able to reimburse that until the terms of the contract were amended to contractually obligate FDOT to reimburse for retirement. Another thing to point out with benefits, these are employer paid benefits. So just like on a pay stub, you'll see where costs are taken off the top of what is paid to the employee for the employee's portion. That's not what we're talking about. So I work for the state. The state of Florida pays a portion of my health insurance, and then an additional portion, which is my portion, comes out of my paycheck. The state of Florida portion is what would be eligible for reimbursement. So that's an example of what we're looking for as supporting documentation is your agency's portion of those benefits that were paid, not the amount that was taken out of the paycheck for the employee, where the employee paid their portion, where you took it off the top of what they got paid. So that's an important caveat to note, that these are employer paid benefits, not what you took off the top of the paycheck of the employee. Personnel services costs are to be submitted on a monthly basis. Part 5 we're going to go over in detail in a minute, but Part 5 requires that any personnel services cost to be submitted on a monthly basis. So if you go 30 days and you work sometime within the next following 30 days, you need to submit a reimbursement claim for those costs that were worked, whether that's a calendar day or 2 biweekly pay periods. But within a month after those first 30 days, you need to submit a reimbursement claim. It does not say that you need to wait to the end of the year and October 31st submit 12 months worth of personnel services. It is intended to be submitted on a monthly basis to make sure that we have time to make sure that you get reimbursed properly, and that if in the event you forgot to include benefits that you intended to be reimbursed for, we can amend that throughout the process to make sure that you're not out money that you actually intended to get reimbursed for. The second section of the budget detail is contractual services. So this is very important to note that line items listed under contractual services actually have a separate approval process. So if you have something that's listed in contractual services where you are hiring someone to come in and do something on behalf of your agency that you can't do for yourself, that it requires a separate contractual service agreement that has specific clauses that need to tie it back to your subgrant, and it needs to be approved by DOT before you execute it with your vendor. And Part 5 gives specific details about how to go about doing that and the approvals that are required and the clauses that are necessary to be included. But at this point, what I want to highlight is that just because you have a subgrant that was awarded October 1st does not mean that if you have a line item for contractual services, you can start working on that with that vendor October 1st, because there is additional approvals and agreements that need to be executed before those costs are eligible for reimbursement. As the recipient of a subgrant, you are subject to all of the terms of Part 5. I'm not going to go over all terms of Part 5, just some of the most problematic ones for subrecipients in the past. It is your responsibility to read Part 5 and know what may or may not apply to you. To see Part 5 by itself, you can click on Performance Indicators form in the system, and then there's a hyperlink that says click here to generate subgrant terms and conditions. And by clicking that, you'll get a copy of Part 5 all by itself, or on your subgrant agreement and amendments signatures page, when you click on that and generate the full PDF, Part 5 is included within, obviously, the pages of your full subgrant agreement. So number 1 on Part 5, Federal Regulations, is access to public records and monitoring. What this indicates is that anything awarded under this subgrant is open to public records and monitoring. Any auditor, any Joe Public, any federal agency can request and be given authority to see anything involved with your subgrant agreement. So number 3 under federal regulation talks about offsets. So if it is determined that an overpayment was made on a previous claim and you do not give a check back to the department, we can offset it on your next claim that you've submitted for reimbursement to recapture any overpayment on a previous claim. Number 11, methods of procurement, requires that the subrecipient follow the federal requirements in the procurement standards for 2 CFR 200 for procuring any funds under the federal agreement. It also requires that when possible, the subrecipient must make all necessary affirmative steps to ensure that minority businesses, women's business enterprises, and labor surplus area firms are used when possible with federal funds under this subgrant. Section 13 is much like the Buy American clause, but there's a domestic preference for procurements. So in addition to those of $5,000 or more, there is a preference as appropriate and to the extent consistent with the law, the subrecipient should buy things made in America or constructed in America. Section 22 talks about termination and suspension. This subgrant can be terminated for convenience in accordance with to CFR 200 within 30 days with advance written notice of the party. It will not affect any charges that have been incurred prior to that point, but can be ended at any point, according to CFR Part 200. There are additional federal encouragements that are provided by NHTSA that are included in Part 5. Law enforcement agencies and all agencies alike need to review and make sure what the encouragements are with regards to vehicle pursuits, policies on seatbelt use, and policies on banning text messages while driving. Much like we saw with federal regulations, there is a state requirement that we comply with public records laws, that we do business in the sunshine, so everything is available for review by the public, state auditors, federal auditors, anyone who wants to see anything. There are no secrets in what we're doing. So as a recipient of a state contract with federal funds, you have to be able to provide, upon request, any review of your documentation or activities. Compliance with the Inspector General is number 32 for the state requirements. So it's the duty of every subrecipient to cooperate with the Inspector General in any investigation, audit, inspection, review, or hearing pursuant to the subgrant agreement. Fraud is a very prevalent issue for NHTSA subgrants. In this example, a Dallas police officer was charged with fraud where he was allegedly paid for 160 hours of overtime, which he justified by submitting 29 false and fraudulent traffic citations for people who didn't exist and events that didn't happen. On August 21st of 2020, the U.S. District Court and for the Northern District of Texas sentenced Matthew Allen Rushing to 3 years of probation, 120 hours of community service, and over $10,000 in restitution and a $100 assessment fee. So it is possible to commit fraud with our funding, which is why we review those reimbursement claims in detail. And if someone commits fraud, the penalty can be very tedious, as you see. Section 38 talks about retention of records. A subrecipient shall retain records demonstrating compliance with the term of the agreement for 5 periods from the date that the final audit report is issued. So for 5 years, and then if no audit is requested, then you can get rid of it in 5 years. If an audit is requested, then you must keep it for 5 years at the end of the audit completion. Number 53 talks about IRS Form 990 for any nonprofit agencies receiving a certain amount of its budget from the state is required to submit an IRS Form 990 annual report in order to receive subrecipient funding. So again, we glossed over some of the state requirements. Now we're moving into grant management, some of the actual details of implementing this particular subgrant. So I mentioned before, your grant says what it means what it says, and if it doesn't say it, we need to amend those terms so that you can operate under new terms that are more appropriate. So prior to making purchases or doing anything that's not specifically allowed, you need to request an amendment and provide justification for those changes to FDOT. And that needs to be signed and executed fully by your agency and FDOT before you start making any purchases or any actions that are not specifically approved. So that's done via our system, via the amendment development, and it goes through the exact same approval as your subgrant did, where you say, hey, I want to make these changes. FDOT reviews those changes to make sure that they're eligible and appropriate. We then submit it to you for signature, Then you submit it back to us for execution, and then it goes back to subgrant awarded under the new terms of the amendment. Section 56 speaks to equipment. So again, this is equipment costing $5,000 or more. It shall be used for the original purpose authorized. If we bought you a light tower, it's meant for checkpoints. It is to be used for checkpoints, not for the county barbecue. It requires additional approval. So as I mentioned, NHTSA has to approve you to purchase it up front, and then you're required to provide biannual certification that it's in good use, you're using it appropriately. And then if you want to get rid of it, if it's extended its useful life, you have to request approval to dispose of it. So Part 5, Section 56 indicates that you have to request approval to dispose of the equipment. So we send that request to NHTSA. They update their records that, hey, this equipment no longer exists in our area of interest. They give us approval to get rid of it, and then if you sell it at auction and receive more than $5,000 back from it, then you need to cut us a check so that we can credit NHTSA back for those costs. The biannual certification and disposal forms are available on our website, our Forms and Resources page. Down at the bottom where it says Other Forms, you see on the screen I've highlighted where the equipment disposition and certification forms can be found. In addition to the fact that NHTSA has interest in it and you're required to certify it biannually, it also says that the subrecipient is responsible for replacement or repair of any equipment that's purchased. It belongs to you, you take care of it. And if you do not use it appropriately, if you're found to be using it for that light tower for the county barbecue instead of checkpoints, FDOT can and will come and repossess it and give it to someone else who will use it for checkpoints. Section 57, this has been amended from 2021 when it was implemented. So equipment purchases for $200 or more, so this is unit cost. This applies to any office, training, communication, or computer supplies, including computers, with a per item unit cost of $200 or more. So before you buy a piece of office equipment, before you buy a piece of training equipment, before you buy a headset for your computer, before you buy a laptop or a monitor or a keyboard for subgrant implementation, if you have line items to support that, if that particular thing you're trying to buy costs $200 or more, then you need to get approval from the safety office before you buy it. So if the monitor costs $300, we need to approve you buying that monitor for $300. If the printer costs $300, we need to approve you buying the printer. This does not, if not expressly mentioned here, it does not apply. So grant says what it means what it says. This only applies to office equipment, training equipment, communication, or computer supplies, including computers with a unit cost of $200 or more. One thing costing $200 or more, not 10 things that have a combined total cost of $200. One item that has a unit cost of $200 or more. So Section 58 talks about excusable delays. So when we award a subgrant, we intend that you go out and start working the grant as soon as possible. Now, there are acts of God and other things that happen that may prevent you actually implementing as quickly as possible. If a subrecipient is unable to fulfill the activities stated in the proposed solution or project objectives of this agreement, the subrecipient must contact the FDOT State Safety Office immediately to discuss potential amendments or alternative plans. Communication is key. We understand things happen, but if you do not communicate with us, we consider that you are non-compliant with executing your grant. This will affect your eligibility for reimbursement in the future. So it's important that you communicate any delays or anything that may prevent you from meeting your objectives. You need to have heavy communication, preferably by email and in writing, with your project number and contract number listed so that we have documentation to support what's going on with your project. So in the beginning of this training, we talked about how concept papers are evaluated for funding based on what they're asking for, in addition to prior performance of the agency. So Section 60 of Part 5 talks about what could make you ineligible for funding in the future. So failure to provide required audits, so this is the single audit requirement, failure to provide your performance reports and final narratives timely, failure to perform, so we talked about excusable delays. There's reasons why you might not be able to, but if you just don't do anything and you don't tell us what was up with that, we may not play with you. Failure to provide reimbursement requests timely. So I mentioned on those personnel services that you should be submitting reimbursement claims monthly. If you submit them quarterly, if you try to submit them annually, that is not timely and in accordance with the terms of the grant and could prevent your eligibility for funding in the future. Providing fraudulent documentation definitely puts you out of the water for receiving grants. And then misuse of equipment. If we determine that that equipment that we provided you, you weren't using appropriately and we had to go repossess it, it could impact your ability to receive funding in the future. It also indicates that overtime is based on the definition of overtime for the agency. So you all have overtime policies, and overtime will be reimbursed based on your overtime policy of your agency. So if you have to work 84 hours at a standard rate before you get time and a half, then we're only going to reimburse costs as they were paid. So if you worked hours 82 through 88, half of those may be straight time and half of those may be paid at time and a half, and will be reimbursed. You'll be reimbursed based on how they were paid according to your policy. Section 363 talks about reports, indicates that there are 3 types of reports that are required for the subgrant: a performance report, a final narrative report, and then activity reports. Performance reports are included with each claim. The performance reports are filled out based on what is included in Part 4 of your subgrant. So if you pull up Part 4 of your subgrant, the very first item that's listed there, you'll see in the screenshot of the performance report, you see a 1 and there's a blank. There's 2 field entry points here. So the very first one is where you reiterate what it says on Part 5 of your subgrant. It says, we'll provide a reimbursement request monthly. And then you said reimbursement provided in that second step underneath it. So there's no question on what goes in the first line of each line of the performance report. It comes directly from Part 4 of your subgrant agreement. And this form is to be completed with every claim that's submitted. If you're an enforcement grant, there are activity measures that should be calculated using the activity report forms that FDOT provided. So if this is an occupant protection HVE grant, you would be reporting any of these 3 activities that were accomplished with subgrant funding while doing that overtime. Same for all other program areas. So the FDOT activity reports are filled out by officer for each activity detail that they complete and helps to gather the information that's necessary to report for this performance report that's required with your claims. So the final narrative is different than the performance report that you provide with the claims every month. Specifically, the final narrative report is a summary, a culmination of everything that you did with subgrant funding for the year. Specifically, we want to hear about the objectives that you were planning to accomplish and whether you did or did not accomplish those. If you were hugely successful, we want to know how you were hugely successful. This information is used to complete our annual report that we send to NHTSA each year. We tell NHTSA we gave this funds to agency so-and-so and they did this or that with it. So this is your opportunity to shine. If you were hugely successful, say how you were successful, what you did differently. This information is shared nationwide. Our neighbors in other states may benefit from something that you're doing and ultimately save lives by copying what you did. If you weren't successful in meeting your objectives, providing a plan for improvement or really being able to identify what challenges you encountered and how to prevent them in the future will be used to evaluate your eligibility for funding in the future as well. One specific thing to notice about the final narrative is that it is due by October 31st each year. Your performance reports are due with every claim, but your final narrative is due by October 31st, which is 30 days after the end of the subgrant period on September 30th. Failure to provide a final narrative report could prevent reimbursement of your final reimbursement claim as well. So please make sure that that final narrative is as glowing as you can make it for yourself. Tell your story, shine, provide pictures. We love to include those with our annual reports as well. But make sure that you get them to FDOT by October 31st. Activity reports are the last type of reports that are required by this subgrant. So these enforcement activity reports can be found on our subgrant website. Each program area has a specific activity report. An officer is to fill out one activity report every time he does a detail. These activity reports are to be submitted with the financial reimbursement claim. So when you're submitting the overtime for that officer working that detail, that activity report should be included. You should be using the appropriate activity report for the appropriate type of enforcement. So if you're doing team enforcement, you're not going to use a speed activity form. Each specific activity report has instruction and kind of an overview of what that program area enforcement is looking for, and then some specifics on what to do in cases of, say, inclement weather and things like that. Each officer fills out these activity reports and it comes with the reimbursement claim so that we can verify what product is coming from the hours that are worked. There are no quotas for writing citations at all. However, we do expect that we're paying for high visibility enforcement. We expect officers to be visibly making contacts during subgrant hours. And so that's something we're looking for when you submit these activity reports. Also, at the very bottom of the activity reports are the totals for the NHTSA activity measures that we have to report to them. So the number of safety belt citations, DUI arrest, and speed citations that are issued while working subgrant funding are reported on these activity reports and then help us to submit those total numbers at the end of the year. So you see at the very bottom of that activity report are where those activity measures show up. And so when you're submitting your performance report for the month, you'll take all of the activity reports and the totals for those three measures, add them up, and you put those grand totals on your performance report for the month. If you only had one officer work one detail, it's pretty easy. But if you had multiple officers work multiple activities, you'll have to add those up to be able to provide your total at the bottom of your performance report for your claim. All of those forms are available on our Traffic Safety Subgrants website under Forms and Resources. So you'll see we have all of the individual activity report forms. We have that performance report that's required for inclusion in your claims. And then we also have the final narrative report that's required at the end of the year. '64 talks about the terms of the subgrant. So the first date that you're eligible to incur cost and receive reimbursement is the award date, and the final date will always be September 30th. So if you, for some reason, got awarded on, say, August 1st, you still have till September 30th to complete those activities. There are no extensions for these annual subgrants. They end on the end of the federal fiscal year on September 30th. '65C talks about prerequisite approvals. I mentioned in the project detail budget that some expense line items had prerequisite approvals also. Travel was one of those. This section indicates that all subgrant travel that has billable cost requires written approval from the FDOT State Safety Office. Additional detail is required if there's purchase of airfare, travel to a conference, a registration fee, out of subgrant specific work area travel, or out of state travel. These additional details were required in the past. The new updates for this year is that all travel with the billable cost requires a written approval. So make sure you're working with your program managers to get those travels in place prior to expending costs for travel. Section D talks about lodging reimbursement limit. It indicates the Department of Financial Services limit of $175 per night. This limit also extends to our subgrants. Therefore, the maximum of $175 per night can be reimbursed for subgrant travel, and that's the rate before taxes and fees. E talks about lodging for subgrant funded statewide coalition meetings and conferences. This indicates that if there is a lodging contract that's executed for the coalition meeting or the state-funded conference, all travelers are expected to use this contract. If they stay at a different hotel with a higher rate when there was rooms available under the contract, they do so at their own expense. Number 67 talks about allowable cost. So costs that are incurred under this subgrant shall be determined allowable in accordance with what the subgrant agreement says. All funds spent in accordance with the applicable federal laws are subject to repayment by for the subrecipient. Only costs directly related to this subgrant agreement shall be allowable. So this goes back to your grant says what it means and it means what it says. If federal law or state law deems it ineligible, then it would be ineligible. But 9 times out of 10, your grant says what it means what it says. If you incur costs in accordance with your subgrant as executed, it is eligible for reimbursement. Section C talks about the additional required clauses that the federal government requires to be included for any subcontract that's executed for this subgrant agreement. Section 69 talks about indirect cost. Indirect costs are included in the subgrant agreement in Part 3, which is the detailed budget. Under indirect line item are based on the indirect cost rates the subrecipient used in their concept paper application process. The rate is applied in accordance with the modified direct cost guidance for 2 CFR 200 and the subrecipient's federally approved rate agreement. Section 71 is the procedures for reimbursement. So this is how you get reimbursed for cost expended under your subgrant agreement. 71A talks about required forms. It says that you must use the FDOT forms and performance report to submit your claim. Your claims must include supporting documentation, which includes proof of payment for each item that you're requesting reimbursement for. The frequency and deadlines for submission are partial claims are to be submitted on a monthly basis or after every 2 biweekly pay period. And then your final claim must be submitted by October 31st, which is 30 days after the end of the subgrant period on September 30th. Section 74 indicates that any activity funded with a subgrant agreement shall not charge a registration fee for attendance. Section 77 speaks directly to enforcement. A says that no subgrant funds will be awarded to carry out a program to purchase, operate, maintain an automated traffic enforcement system. It states that all enforcement will be data-driven, based on activity locations that identify high-risk areas with the greatest numbers of crashes, serious injuries, fatalities, and/or traffic violations. 77C further defines what high visibility enforcement is. High visibility enforcement is defined as intense, frequent, visible, and strategic. (77E through H) speaks to the specific enforcement areas covered by subgrant funding. 77E is impaired driving enforcement. Hours of emphasis, mobilization participation, and required credentials for impaired driving enforcement are covered in this section. Those specifics are not detailed in this presentation. However, if you've received an impaired driving enforcement grant, please refer to 77E to understand the specifics of those requirements. 77F speaks to motorcycle enforcement. It says that no subgrants will be used to check helmet usage or create checkpoints that specifically target motorcyclists. G speaks to occupant protection enforcement and indicates that all enforcement agencies that receive occupant protection subgrant funding will participate in NHTSA occupant protection mobilizations for click it or ticket, and that safety belt enforcement is encouraged for both day and nighttime. 77H speaks to speed and aggressive driving enforcement. This states that all agencies that receive speed and aggressive driving subgrants should participate in NHTSA's Regional Speed and Aggressive Driving Mobilization for Operation Southern Slowdown. Any law enforcement officer who is using a radar or laser speed detection system must be certified in the use of that piece of equipment. Before printing or ordering any information or educational items, a final draft or drawing of these items shall be submitted to the FDOT State Safety Office and reviewed for approval. Requests should include what the item is, what policy or program it's supporting, who the target audience is, how the item will be distributed, the estimated costs per unit for each of the items, and where feasible, the Department of Transportation logo or words or funded by FDOT must appear on the items. Brought to you by or provided by may also be used for this requirement. The name of the subrecipient and its logos can appear on any public information educational items. The names of individuals connected with the subrecipient shall not appear on any printed materials and advertisement paid for with highway safety funds. Additionally, Section 79 references the memo of May 2016 that prohibited the purchase of backpacks, cups, flashlights, keychains, magnets, shirts, sunglasses, and umbrellas. Therefore, they are still unallowable under this subgrant. Section 80 speaks to publication and printing of observational surveys and other reports. This indicates that if a survey or other report was conducted with subgrant funding, that the final draft of any report must be submitted to the FDOT State Safety Office for approval with at least 15 days prior to written notice of publication. One last reminder, your subgrant agreement says what it means and it means what it says. If it doesn't say it, it doesn't mean it, and it will be evaluated based on what it says. 90% of the questions that you'll have can be found in your proposed solutions. The objectives that you intend to accomplish, how you'll be evaluated is included in your evaluation. What you're required to provide performance reports on is in your performance indicators area. And then any question about what you can or can't do can be found in Part 5. So please refer to your subgrant agreement as your number one-stop shop for answering your questions of how to proceed with subgrant success in fiscal year 2023. And while Part 5 and your subgrant agreement is the first place you should go, the FDOT State Safety Office Subgrants website is probably the second place. The website provides all of your forms that you need for reimbursement, your activity reporting, your final narrative, and the clauses that you need for your subgrant subcontracts. There's also a reimbursement reference guide which gives you step-by-step instructions on how to fill out each reimbursement form. Again, Part 5 of your subgrant agreement answers 90% of what you can do and how to do it. The other 10% talks about how you entered your proposed solution and your budget detail. Your program manager can fill in the gaps for everything else. So please use the resources that are available to you to ensure your success. I hope you found this information helpful and you feel prepared for success in the 2023 year. And as always, reach out if you have any questions.